Ms MacDonald.
Lords, I propose to take the next step in my submissions about the Jackson reforms by the Court of Appeal case I've alluded to but not yet shown you. After I've dealt with the Jackson reforms, I propose to come straight back to Lord Legate's question and then go on to our other key points that I identified at the outset of my submissions. Just before the short adjournment, I had introduced the Jackson reforms as a package, which is the wording that's used in the MOJ recommendation and indeed is repeated in the Court of Appeal case, which is at Supplemental Bundle 1553. Hopefully that's reached all of your lordships because it was a late edition. The reason this came about as a late edition is because this case is actually mentioned in a footnote in the appellant's case, but we realised that in fact there were two decisions with two different neutral citations back to back almost that are reported.
I'm sorry, Ms MacDonald. I wonder if you could bear with us just for a moment. There seems to be a problem.
We all having the same problem.
Would your lordship like the page reference again?
No, I'm having difficulty getting into the
Into the bundle.
can't open any of the bundles at the moment, other than the main one.
So, is this the supplemental authorities bundle?
It was updated
The other day.
Can't get into
That's
the bundles. If I click on there.
It's updated on Tuesday, my lords.
What's the name of the case?
Right.
It's called Simmons and Castle. It's at the very back of the updated supplementary
Okay,
bundle.
thank you. Can you
Page
close that?
1553.
You can get
Page?
back in.
1553.
And it's the supplemental bundle.
It is.
Well, no, because
I've got Simmons and Castle.
So Simmons against Castle.
Simmons and Castle.
I've got it as additional case bundle, or additional cases.
It's also at the end of the supplemental authorities, the latest supplemental authorities bundle.
yeah,
But
I think it was sent to the court in both.
supplemental authorities bundle
yeah,
of the 10th of January.
I've got a feeling it's the 11th actually. Sorry,
Right.
no, it's the
Yes, 16th of January. Thank you.
no, it's the sorry. I've got one of the 18th, which is what I've got.
Thank you. Thank you very much. Right, and it's page 1553 of that.
Indeed. Do your lordships all have that page now?
Yes, I do.
Yes, I do.
Very grateful.
Thank you. And I'm very sorry.
No, not at all. My lords, as I was saying a moment ago, your lordships will see at the top of the page in the report there are two different neutral citations.
Yes.
And the two decisions are reported back to back in this same report, in the same volume of the weekly law reports. You can see from the dates, in fact, of the decisions that they were only weeks apart. The first one being in July, the second one being in October. In a nutshell, what happened was that in the second one, the Court of Appeal slightly amended its previous decision. As I said a moment ago, the neutral citation given in the footnote in the appellant's case is a bit misleading because that refers to the earlier judgment, which was then varied. So they're short judgments. May I make a humble request that your lordships read them both, which won't take very long after the hearing today,
Yes.
because they contain an extremely useful summary of the implementation process of the Jackson reforms, and particularly the 10% increase in general damages. which I will merely summarise now, given the time allotted to me. I would ask your lordships to note the eminence of the panel dealing with this. The Lord Chief Justice, the Master of the Rolls, and Lord Justice Kay was at the time the Vice President of the Court of Appeal. In the first of the decisions, at paragraph 7 to 17, at page 1554, which I will not read out, the Lord Chief Justice goes through the history of the Jackson reforms and why it's necessary for the Court of Appeal to implement the recommended increase in general damages, because that, as I said before the short adjournment, is a common law point. The judicial guidelines, which any of your lordships who's got experience of PI claims may recall from Kemp and Kemp. For some of us, one has to go back to bar school to remember those days. But those are effectively a summary, as I understand it, of decisions made by judges, and they're published every 2 years to achieve consistency in terms of general damages between the various courts. But it is the courts themselves who create the law, modify it, develop it, etc., in relation to general damages. So the changes that were implemented in the law to implement one of Lord Justice Jackson's recommendations, the 10% of general damages, was not done by statute, was not done by statutory instrument. It was done at common law. And of course, one of the overarching points I take out of that is that it's implicit within the fact that the Court of Appeal did so in 2012, that there was no problem created by Section 58A6. In fact, reading these two decisions, I can't see that 58A6 was really regarded as an obstacle at all. It's not really mentioned. It'll be for your lordships, of course, hopefully, to read the judgments. But despite the eminence of the judges in the Court of Appeal looking at this, despite the fact that by the time it came to the second hearing, there was very robust advocacy by the Association of British Insurers, by the PI Bar Association, and by the Association of Personal Injury Lawyers, that this point just was not taken. It appears, in summary, to have been taken as read that increasing general damages by 10% in no way offended the prohibition on recovering success fees by way of cost orders.
But wasn't that what Jackson had recommended?
My lord, the 10% increase, or the both as part of a package.
Yeah, it was part of a package.
Yeah.
Well, it would be extraordinary if the court, in a sense, accepted the package, but then said, well, it's got nothing to do with success fees. I mean, that's the base on which they were operating.
My lord, absolutely, absolutely, and the package.
But my point to you is, we haven't got that package here. We haven't got a Jackson review. We haven't got somebody who's spent a great deal of time looking at the policy implications. How can we now do the sort of role that was done by a specially convened court in Simmons and Castle precisely to carry out those policy recommendations?
Well, my lord, there are two main points that I take out of Simmons and Castle. One is, which I've already made, that it was the premise of the decision is that Section 58A did not create a statutory obstacle to formulating an increase in general damages directly referable to success fees. And I will show you the words in a moment where that's made clear.
They may be referable in the sense that they were both part of the same proposal, but it wasn't limited, the 10%, to cases where people were on a success fee, was it? Just an across-the-board increase in... and equally, if you're on a success fee and your claim is just for financial loss and not for pain and suffering, you don't get the 10%. So the two don't match each other in that way.
My Lord, it was expressly acknowledged that it was not a perfect solution. And we see that within this decision of the Court of Appeal, which cites, amongst other things, Lord Justice Jackson's own implementation lectures, which you don't have anything to do with that in this bundle, unfortunately, but it appears that he himself commented on the proposed reforms as he did these lectures. Now, it is acknowledged, first, that there's a package of reforms, and Lord Justice Jackson implored anybody implementing the reforms not to cherry pick. It had to be a package. There was giving, there was taking. It was expressly acknowledged it was not perfect. One example of the imperfection, my lords, being that you would have the windfall that my Lord Stevens identified before the short adjournment. Of course, there were going to be claimants who got their 10% increase in general damages who didn't need it, and it was a complete windfall for them because they were privately funded.
I have great difficulty about it being described as a windfall when there is a thing called inflation. And I also have huge difficulty in equiparating a success fee, the amount of a success fee, with a 10% increase in general damages.
My Lord,
I don't see how they can... It might have been a method of selling the proposition, or putting a package together, but they don't really hang together at all.
my Lord, I think the answer is that there will be a range. Sometimes they will not hang together at all. Some people will not find their success fee is covered by the 10% increase. At the other end of the spectrum, some people will not need it and have the windfall.
Huge difficulty in seeing how a 72% success fee could possibly be covered by a increase in costs. Could be possibly covered by a 10% increase in general damages. If you say the general damages are £10,000 or 20 or whatever it may be.
Well, my Lord, I think...
Not to worry, I mean, it's a small point.
Well, no, it does matter. I wonder if I can show you the answer to that point that we have been able to find,
yes,
which is in the supplemental bundle at 1396. And what we have, when we were looking for an answer to that particular question, the only one we can find is in paragraph 5.4 on this page, where there is reference to the advice of an economist, Professor Paul Fenn, that such an increase in general damages will, in the great majority of cases, leave claimants no worse off. So my Lord, clearly the 10% figure came from somewhere. And indeed, clearly the 25% cap that's in 5.3 Roman 2 on the same page came from somewhere. And as far as we can tell, there was this input from an economist, which we infer led to these figures being alighted on. My Lord, that's the best I can do in helping your Lordship on that point. But another answer is to be found in the Court of Appeal case that I've asked you to read, because it is explained in that case very clearly how the windfall point operates, that clearly there are going to be people who are better off. And that is, and reference was made in the course of argument by the time of the second hearing. I hope your Lordships will forgive me just dealing with it like this.
I think Lord Stevens' objection is more to somebody who's lost a leg being told they're getting a windfall because they're getting 10% more damages, rather than to the point that they may be no worse off overall.
well, I understand that point, but that's perhaps not for. I'm not sure I can add anything to that. Can I come back to how the windfall operates in relation to this case and why it's relevant? The point about the windfall was made robustly in argument for the purposes of the second hearing in the Court of Appeal. And it was because it was said that that stopped it really just being a reference to the success fee and detracted from it. And it's clearly explained, and perhaps I can actually ask you to go back to Simmons and Castle, and particularly at page 1562, where the Lord Chief Justice said at paragraphs 26 and 27, 26 making the point about the package of reforms and it not being perfect, and then in 27 saying it's clear from these observations that both Sir Rupert and the MOJ envisaged and intended the primary purpose of the 10% increase was to compensate successful claimants as a class, pausing there, very different in our case because we're talking about tailor-made relief, for being deprived of the right they'd enjoyed since 2000 to recover success fees. And that the final sentence of that paragraph, it appears clear the MOJ regarded the proposed 10% increase as being a quid pro quo for depriving successful claimants of the right, of the ability to recover success fees. Now, in fact, having said it was the primary purpose, your lordships will find, if you go on to paragraph 37 at page 1564, that in fact the second time that this windfall point is referred to, it's referred to a little bit more, even more closely linked to success fees. And the windfall point is presented in the fourth line, as we have already explained, as simply being a counter-argument to a counter-argument, rather than being part of the actual primary purpose of the increase. And the most important point, my lords, is at the end of this judgment at page 1566, when I should perhaps ask you just to glance at the previous page. At paragraph 46, there's a discussion of to what should the 10% increase apply. And your lordships will recall that in the Jackson report, it was supposed to apply to tortious claims. And in fact, what the Court of Appeal did, which of course was absolutely within their purview to do, was to extend it to claims in contract as well. And in fact, they ended up over the page at paragraph 48, developing the common law by saying at paragraph 48 that the 10% increase was going to apply to what is defined in or described in McGregor on damages as non-pecuniary damages, and then make it clear that there are four types referable to both tort and contract. And then in terms of the actual modification of the previous decision, and this is one of the reasons why the ABI got involved at this point, they introduced what they described as a sort of quasi-transitional provision, so that it would only apply to people, and you see the wording of this in the very final paragraph on that page, it was only going to apply to claimants who had CFAs where you could not recover the success fee by a costs order. And that's the reference halfway down that paragraph to section 48.6. So you've got as I said before the short adjournment, you've got an absolutely straight line between the 10% increase in general damages and the irrecoverability through a costs order of the CFA success fee.
And is your central submission that this is a model for what the Court of Appeal has done here and what we should be doing?
My lord, there are
is that
two.
the point?
the points I take out of this are twofold. Firstly, and forgive me for repeating myself a bit, firstly, that the fact that the Court of Appeal readily did this, readily in the sense that they regarded themselves as having an obligation to do it, the fact that they readily did it and were not concerned that by doing this they were offending against the irrecoverability of success fees by way of a costs order demonstrates that Section 58A is limited in the way that we say it is, that all it's dealing with is recoverability of success fees by a costs order. It does not prohibit success fees that may be properly recoverable through other means. Here, through general damages, we obviously say through the mechanism of the Act, which is not limited in any way to omit such recoverability. The second point I make that arises out of this whole package of reforms and the 10% increase is that it is not right to say or to describe the Jackson reforms as success fees shouldn't be recoverable. There's a sort of hard concrete wall between them being recoverable from anybody other than from any losing party or anybody on the other side of the courtroom. There are ways, this is one of them, the 75 Act is another, and I will develop that point. There are ways of quite properly allowing success fees to be recoverable. And I say again, it is
wholly different, isn't it? Because first of all, there's no, as you accept, direct correspondence at all between the success fee and the general damages, and secondly, because they are general damages. I think if the argument had been, well, we'd like you to say that you add on 10% to the calculated loss in order to make up for the loss of the success fee, it would have got quite a different response from the Court of Appeal. General damages don't exist as money except what the court sets on them by way of a convention. But we're talking in this case about purely money and what people have to spend and what they don't, and whether they spend it on costs or whether they spend it on rent.
My Lord, I agree with that, and it's absolutely at the heart of our case that 75 Act claims are not damages claims. The exercise that the court is carrying out is totally different. It is not seeking to compensate somebody for loss, whether it's a pain and suffering kind of loss or a loss of earnings. That is not what the 75 Act is doing. Ultimately, what the court does certainly in non-spousal 75 Act claims is to, and what the court has to do in all 75 Act claims is carry out a holistic, comprehensive analysis of all of the factors in Section 3.1, including a claimant's financial situation, both now and in the future. And it is assessing at the date of the trial the current and likely, that's the wording in the Act, financial resources, financial needs, doing the best it can at the date of the trial to understand what those figures might be. And ultimately, in claims such as ours, where somebody is living at pretty much at subsistence level and is struggling on £1,000 a month income with 2 small children, and every single bill is a worry, the court has to look extremely closely at that kind of claimant's ability to fund the basics of life.
I mean, isn't there another difference that in the personal injury scenario, we haven't quite got the same knock-on effect? I mean, the effect clearly of allowing the success fee to be recoverable as part of the 1975 Act is that you are going to diminish the overall resources or assets left to the estate. Now, that isn't quite paralleled in the personal injury scenario.
Absolutely.
So that's an underlying it seems to me, difference. I would have thought that the argument that you're making would lead us to think, well, what's needed? There's a problem here. What's needed is a policy review that is likely to come out with something like there ought to be an automatic uplift in certain circumstances. So much of a success fee should be, that might be one way of doing this, should be available under the 1975 Inheritance Act. But we haven't got that policy review. So in a sense, you're asking us to do something extremely radical, given that the Simmons case, which you're pinning a lot of our ability to do this on, was preceded by very careful policy analyses which came up with not a perfect package, but a policy across the board package of an uplift.
My Lord, two answers to that. Firstly, I'm absolutely not asking you to do anything radical. On our case, what we are asking you to do is absolutely not radical. Secondly, I do take quite a big point out of Simmons, but it only goes so far. Of course, the context of Simmons is completely different to 75 Act claims. And I'm very happy to accept that the sort of considerations that my Lord has identified are obviously not going to apply in 75 Act cases. And absolutely right as well that within a 75 Act case, one of the mandatory criteria the court has to consider is the position of the other beneficiaries in the estate as well as any other claimants. So, yes, all of that makes these cases different. What Simmons and Castle does, and the reason that I've spent time introducing it to your lordships, is, first of all, it is completely contrary to the appellant's case that Section 58A6 is a concrete prohibition on any form of recovery referable to a success fee, because if she's right, then this decision must be wrong.
I mean, I think the difficulty with that is that that Simmons was not a decision for the recovery of a success fee. I mean, can I put this to you? Do you regard Simmons and Clark as authority for a court in an individual tort case increasing the award of damages to include a success fee?
No, but I don't. But the similarity. No, I don't, my lord.
Well, then you're shooting down a straw man, because the argument against you doesn't have to say that it's never possible to do anything in life to redress the injustice of not being able to recover a success fee. All it says is that you can't get the success fee by a different route if you're not allowed to get it as costs.
Both Simmons and Castle in the context of the general damages and our case in the context of the 75 Act claim involve the court making orders which are not cost orders. And this case demonstrates that that can be done. It doesn't offend.
They didn't make an order, did they?
For general damages.
On general. Did they actually make an order in that case, or did they alter the guidelines?
They
actually made an order, did they?
Yeah.
It wasn't an order for the payment of a success fee.
No, but my lord, but neither was ours.
Well, I think
it was. It was in our case, as in every 75 Act claim in which a lump sum is ordered, the order is for the payment of the lump sum.
Well, broken down to include £16,000 to pay the success fee.
Well, that leads on to an interesting point, because yes, in some cases, as in this case, you've got the precise maths to get to a figure. Yeah. That will not always happen. Sometimes you will have judges reaching a figure without quite such precise calculation. And of course, in many cases, as I alluded to at the outset of my submissions, you will have non-monetary forms of relief. Now, again, on the claimant's on the appellant's case, if you had a 75 Act claimant who couldn't pay the rent because they faced this success fee liability, and it was and the court decided it was appropriate to grant them a licence in one of the estate properties or some form of accommodation, possibly for a limited period of time, that would the court would only have made such an order because of the liability for the success fee, or at least that would be a key reason for doing it. And indirectly, it would enable the claimant to fund the success fee, as did the lump sum order in this case enable the claimant to fund a success fee. On the appellant's case, even a non-monetary form of relief, which has been reached because of the existence of a success fee, would be impermissible. And the appellant still has not explained how her case fits with the 6 out of 8 forms of relief in this Act, which are non-monetary. In fact, I would say 7, because the periodical payments form of relief is not really ideal to deal with somebody's outstanding liability for a debt like a success fee.
Well, presumably the case is you ignore the success fee in deciding what relief should be granted.
Well, doesn't matter what sort of order
it doesn't matter what sort of order it is. They're all trying to redress a financial situation one way or another. And the case against you is in looking at that financial situation, you ignore the fact that in the real world the person's going to be worse off because of the success fee.
Well, my lord,
I don't think there's any other way of dealing with it. It must be that or not, or your position. I can't see there's a halfway house in which you take it into account for some orders but not for others.
Either the appellant must be saying that at the stage of which learned friend Mr. Wagstaff calls the computation stage. I think that's a term that's more common in the family division. At the computation stage, the fact-finding stage, the court simply ignores any liability for a success fee, and it can't even add up. It can't even be a debt. We say that just can't be right because the words of the Act are not limited. Second,
it doesn't depend upon it being a debt. It just depends on its character as a success fee. It may very well be a debt. It is a debt.
Yeah. What I'm getting at is the stage at which you would have to take into account. If, as a matter of pure fact, it's a debt, then the next question would be, when you are deciding whether whether there should be any relief, and B, if so, what form of relief it should be. As we understand it on the appellant's case, at some point in that exercise, you would have to decide you just can't have reference to that particular kind of debt at all, either because of policy reasons, because of the perception of what the Jackson reforms do, which we say is mistaken, in fact, and I'll come back to that, or you say, even if I wanted to, I can't because Section 58A6 is a hard, concrete prohibition. Now, coming back, just to finish this point on Simmons and Castle, we say that it demonstrates that 58A6 is not a concrete wall to that, probably labouring that point. And on the question of policy, we say that actually, when you look at the Jackson reforms, and I think what I'm saying is probably largely in our written case, so in the interest of time, I won't spend too long on it. Jackson is far more than just saying no recoverability at success fees. There is a package, as far as I've showed you, this general damages are concerned. There is an attempt to counterbalance the effect of the reforms. Now, as far as 75 Act claimants are concerned, in the context of Jackson, they are barely mentioned. Barely mentioned. We've given you in our case the references. There was a general commentary on chancery claims, which is a difficult, obviously chancery claims to some of us would be very broad, but in any way, that they were in that context, and it was observed by Lord Justice Jackson that, and I don't, with huge respect to him, entirely agree with this observation, that CFAs aren't appropriate in chancery claims. Well, they may not be terribly common, but they are not uncommon.
Well, they're sufficiently common that the Chancery Bar Association has a standard form, which indeed was used by counsel in this case.
And always has had, absolutely. That was introduced quite shortly after they became, yeah. And in fact, the Law Society's got a standard form too, just in passing, which, but in the context of disputes about wills, disputes about estates and 75 Act claims, they are not uncommon. At the time, though, when the Jackson reforms were being carried out, they had legal aid. And as with Heather Eilott, in fact, in her very long-running litigation, she started off with legal aid. So somebody in my client's situation, living on £1,000 a month, clearly should qualify for legal aid to bring her 75 Act claim. Then, the key point on this that I need to stress to your lordships is that in the Jackson reforms, he himself stressed that it was vitally necessary that legal aid continue. So it was part of the framework of his reforms that there would be no further cuts in legal aid, and the page reference for that is in the supplemental bundle at 1377.
All this goes to Lord Burroughs' point, though, that what you need is a policy review, not that the courts can make up for what wasn't done, that Lord Justice Jackson recommended, or what he should, or for what he didn't recommend but should have done if he thought about it.
My Lord, I would say that whether or not there is a policy review, either about this or indeed the broader point identified by Mr. Justice Briggs as he was in Lillyman, that doesn't detract from the merits of our position in this case, because what you are looking at, what you've been asked to look at in this case, is whether or not, as a matter of law, it was even open to Mr. Justice Cohen at first instance to include in his mathematical calculation of the award a figure referable to the success fee. And in fact, may I observe as part of that, that like any other liability, he scrutinised what amount he was going to include. The success fee contractually is 72%, was 72%. He said that he was going to allow a figure of about 25%. And like any other liability, and like every other aspect of a claimant's schedule of needs in these cases, the court goes through them with a fine-tooth comb. If there were, for example, a loan which a claimant had taken out, as I understand they often do in family proceedings, a soft loan from a family member, the court will scrutinise. Is it repayable? When's it repayable? What are the terms? What's the interest?
My problem is including in that assessment things that are for the taxing master normally. I mean, I see it as broader than success fees. If your approach is right, it could become the standard practice to say, well, I'm not on a success fee, but the costs I'm going to have to pay to my solicitor are a lot more than I'm going to recover if I'm successful in this litigation. Therefore, you've got to include in your calculation the shortfall, and it's X. Here's my bill of costs that my solicitors sent me, and we'll have to take a view about what will be recoverable on taxation. Then the difference, I'd like you to hand back to me, please, as part of this claim.
Well, my Lord, I'll go back into my order in a moment, but absolutely, it's a key question. I was asked it in the Court of Appeal as well. And the answer to it is that it is Section 3.5 of the Act, which I think my Lord Richards referred to this morning. It's the very important subsection which says the judge has to take account of matters as they are at the date of the hearing, the trial. Now, at the date of the trial, the judge knows, in virtually every case, the judge knows that he or she does not know what costs order will be made under the CPR, because a judge at trial knows that they not only do not know about all the privileged material about settlement discussions, but also they won't really have been presented with the other material that could be relevant to costs, i.e. the raft of correspondence there might be about disclosure or somebody behaving unreasonably, all of the stuff that one comes out with at a consequential stage. Now, as we've, I think, already said in our written case, of course one can see that in virtually every case, a trial judge will say to themselves, I do not know enough.
Well, then I could ask for more. I'd like all the correspondence, please, and if I need to go through the loans with a fine-tooth comb, I'll go through the costs with a fine-tooth comb, if that's the exercise required. The objection is much more fundamental than just a matter of what you know or don't know. It's a matter of whether it's right in principle to give someone, by way of a substantive award, what you can't give them because they're not allowed it, as part of a costs order, but is achieving the same effect by a different route.
Well, Lord, obviously that's the absolute crux of this appeal. But just finishing my point on the base cost point, we can look at it the other way round. One could conceive of a case, and I can't give you an example, well, I can possibly give you one example. One can conceive of a case where, adopting more of a family law approach, the parties go to court and say, we've made open offers, it's a straightforward case, we just can't agree what the relief should be. And say to the judge, you've got everything you actually need to understand the cost position. Our case is, insofar as we need to make a case on base costs, that it would be open to the judge in a very unusual situation like that to make an award which included a figure for base costs. Now, of course, if that were done in such an unusual case, there couldn't be double recovery of such costs. They would have to be taken out of account or at the consequential stage. My lords, that doesn't happen anyway, because in these cases that get as far as trial, there are inevitably matters which a trial judge can't know about until after judgment. And I absolutely respect this slightly separate point on this, that of course judges say to themselves, it's not for me to include costs because they are dealt with. I am directed to deal with costs under the civil cost regime.
But isn't that, I mean, so the point you're making, which seems a fair point, is that the judge simply cannot forecast what's going to happen on costs because he does not and cannot have the relevant information. But isn't that equally applicable to the success fee?
Well, this not directly, but a point has been made since the outset of this case that because a success fee is calculated as a percentage of base costs, that there is a difficulty in awarding a success fee on base costs that may not, as a percentage of costs that may not be awarded into parties.
That's one difficulty. The other is there might have been a Part 36 offer that you can't know about, and so the success fee might turn out not to be success after all.
Absolutely, and that's something we've acknowledged, and I hope that we've actually dealt with this already in our written case.
Well, your answer is to correct it if it turns out to be wrong, is it?
My lord, no. I say that they're dealing with rather the different things. Within the civil cost regime, Part 36 operates as a system.
Can the judge go back to change the order he made? Can the judge go back to change the order he made when he finds out a true position about costs?
It wasn't that he finds out the Part 36 offer, so what he thought was a success fee turns out to be not payable at all, so he's awarded, taken into account a sum which he shouldn't have done.
My lord, within the very restricted confines in the way that any judgment can be revisited or an appeal, but that's not part of our case.
My understanding, as soon as the order is made, actually written, that is the end of that judge's function.
My Lord, we've anticipated that obviously this could arise in certain cases. The answer is to be found in section 2.4, which I showed your lordships earlier, that the court can and does make orders which are contingent. Now, can I add to that point this, that in the context of a success fee, like any other liability the claimant has, they've got to prove it. And they cannot reasonably expect a trial judge to take into account any debt, including a success fee, if they haven't given the judge sufficient evidence of it. That may take the form of disclosing it. It may take the form, as in this case, of simply giving evidence about it at trial, which the judge heard already.
But I think the real problem is the contingency of what's going to happen with the base fees. I mean, it seems to me inconceivable that the court, if it had power to order the payment of a success fee, would do so in circumstances where it refused to order payment of base costs. And equally, I should have thought it was inconceivable, if it's right that, an amount could be included for a success fee in an order under the 1975 Act, that the court would do so in circumstances where it had refused the claimant her costs.
My Lord, firstly, the success fee is only going to be payable, if the claim succeeds.
We assume it has, yes.
Of course. So the criteria for it being payable are very different to the criteria for the base costs, for the order that's made on costs. And I perfectly understand that there could be cases where there is an unattractive, an unattractive order to be made, in the sense that somebody who got a figure referable to a success fee turned out to have behaved outrageously in the litigation, or refused a very...
We don't know why, but the court orders, for whatever reason, that either no cost, none of the claimant's costs are paid by the defendant, or only a small proportion. Yep. Well, the success fee is part of the costs payable by her to her solicitors.
Of course it is on a contractual basis, but,
no, but
my Lord,
I mean, conceptually and in every way. I mean, are you actually arguing for a result where there is no order as regards the base costs, but nonetheless an order could properly be made under the 75 Act?
Yes, can I explain why? Absolutely, absolutely. Because success fee has had to be incurred to get access to justice, to be able to bring the claim.
But so have the base costs, haven't they?
My Lord, they are different in the sense that if the liability for the success fee has had to be incurred at the beginning, we've described it as prospective funding, and I need to come back to section 5 on this point before I run out of time. The success fee has had to be incurred because the claimant had no other way of doing it. The claimant in that scenario, who acts unreasonably in such a way as to deprive herself of base costs, has only got herself to blame. The costs regime within the CPR contains the whole gamut of penalties and rewards in order to encourage good behaviour, discourage bad behaviour. So they are very different considerations.
Why are they so different? Because, I mean, in order to get access to justice, she's had to retain the solicitors on terms which provide for the payment of base costs and, if she succeeds, and her success fee, don't they? Or does she only pay the base costs if she recovers them from the other side?
Well, that could be a term.
But what is...
I mean, normally they're payable anyway, I would have thought. Well, they may not be recoverable in practice, but that's another matter.
It's not uncommon. In fact, it's specifically referred to in the CPR that you can have circumstances where, and it doesn't offend the indemnity principle, if you have a term that says that you only pay solicitor-client-based costs.
I think what I'm
if
trying
they're
to
recovered.
understand is what the conceptual difference is between the base costs and the success fee, because it just seems to me all part of the solicitor's remuneration.
Well, yes, it is, but the success fee element of it is not recoverable, the most obvious point in the world. It's not recoverable, whereas base costs are, if the claimant wins the claim and behaves properly in the litigation. Right. Now, that is the difference, my lord, because yes, of course, on a solicitor and client basis, of course they're the same, the same basis. But the claimant had, let's say on the evidence, as in this case, no other means of going to court other than a CFA. And in many cases, that'll be an absolute requirement.
But a slightly different point, and I really would be grateful for your assistance on it, and that is that conditional fee arrangements were against public policy. They were legalised, allowed to be used, and a package was then introduced which dealt with both costs, how you could recover costs, or if you could recover costs, and actually permitting those arrangements to take place. Mm-hmm. And what was envisaged at that stage was that costs would be recovered through what you call a traditional costs order. And isn't that by itself an indication that when one's looking at success fees, one has to consider them in that context, namely that these are specific arrangements made for costs, and so that they don't fall within the 1975 Act. These are actual practical arrangements made out with the 1975 Act.
Lord, the fact that they were originally to be recoverable, the fact that they were to be recoverable by way of a costs order does not mean that they could not be recoverable through other means. Now, absolutely, before they became...
Was it envisaged that they would be recoverable through other means at the time this package was introduced?
As far as we are aware, well, we are not aware of anything that says that the only way in which they were to be recoverable was a costs order. But, my lord, I suspect that the answer to your question is that because for virtually the whole of the period, for the whole of the lifetime of CFAs with success fees up until 2013, it really never came before the courts in that sense, because those sorts of claimants had legal aid. And so I can't direct you to something that demonstrates exactly how it would have been dealt with had this issue come up in the year 2001. But my lord, going to the, I mean, we've made a. I'm sort of slightly jumping around now because I'm very conscious of the time. Can I come back, please, just to complete the Simmons and Castle point? The fact that you have the Court of Appeal making that decision, we say in and of itself demonstrates that such provision can be made, in that case through the means of general damages, without contravening Section 58A6 in the Jackson Reforms. Indeed, and the policy point, which we do urge upon your lordships, is that if Jackson is premised, as it was, on legal aid continuing, and I must give you the page reference to where he says it's a vital necessity for legal aid to continue. The page reference is 1377 in the supplemental bundle. That was then removed, and that removed a key part of the structure that Jackson was proposing. Your lordships may ask yourselves, in terms of policy, if somebody had said to us, to Lord Justice Jackson at the time of putting together the report, by the way, CFAs are not that uncommon in 75 Act claims, and there's not going to be any legal aid for them, I would submit that it is extremely likely that he would have made more express recommendation about how they provided for. Now, before
but the point's been made, Ms. MacDonald, by Lord Burrows, that on that occasion there was a very extensive review carried out of all the different aspects of it.
Yeah.
Am I right in understanding that you're inviting us to adopt a new policy as a new departure on the basis of speculation as to what Lord Justice Jackson might have proposed?
My Lord, no.
Had he appreciated that legal aid would not continue?
My lords, no, you don't need to. The point I take is that there is a route which has been found to exist both at first instance and by the Court of Appeal in this case, that rests on the actual wording of Section 50A6, which only applies to a costs order, and which relies on the breadth of the wording in Section 3 and what the 75 Act there is designed to do. You're not offending any of that by adopting the approach which we ask you to adopt. There's nothing radical about it. All you are doing is recognising that by making an award under the 75 Act, calculated to include a success fee, the court is exercising a jurisdiction wholly different to the jurisdiction it exercises under the civil costs regime. I'm running out of time to...
Sorry to ask a question when you haven't got much time anyway, but you said before lunch you were going to address a question I asked about whether there's an analogy with damages. You may think you have already, but just so I'm clear what your answer is, why is it not similar to the fact that you cannot recover as damages what you can't recover as costs?
My Lord, absolutely. What the 75 Act has got nothing to do with loss. It's got nothing to do with damages. It's got nothing to do with wrongdoing. In many cases, the testator will have died intestate. Very common in this country. So there's no suggestion of wrongdoing or compensation for loss. The exercise the court is carrying out is holistic, comprehensive, practical, real world, by reference to not even just the claimant's circumstances, but those of the other claimants, the beneficiaries, the size and nature of the estate, and so on. They are unique claims within civil litigation, totally unique, other than the
so you're about to tell us that we're about to hear that they're not very unique because they're very similar matrimonial claims, aren't they?
But Lord, they're not damages claims.
No.
It's a very short point. They are not damages claims. And the award that is paid, if I can very quickly respond to a point that was made by my learned friend this morning, the relief that is granted will, because it's in maintenance-based claimants, it's so focused on the daily living expenses. This case is a classic example where the court is looking at how is the claimant going to be able to have enough income to feed her children and to put clothes on their backs, knowing that she's got no earning capacity because she's been too ill to work for 9 years by the time it gets to trial. And the whole point of the award is designed to enable her to go back to work so that she can fend for herself, which is why it's geared around this 3 years of therapy and income support from the estate. So in a claim like that, all the court is absolutely laser focused on the day-to-day future over that period for the claimant, and is there going to be such a burden on her finances that she will not be able to pay those bills? So, and that will be the case in many of these maintenance-based claims. So regardless of what kind of debt it is the existence of the debt, not the nature of the debt itself. The debt does not have to have anything directly to do with rent, household expenses and so on. What else could my client reasonably have done in this case? Section 5 relief was really not realistically available given the defendant's lack of engagement. She couldn't have represented herself. Very unlikely to get somebody to act pro bono. Claims by adult children are notoriously quite tricky, at least in the first stages. Or just not bring a claim. Access to justice denied.
Why wouldn't Section 5 apply?
Section 5, my lord, enables claimants to apply for interim provision. It's dealt with us.
Based on financial needs.
Well, my lord,
the same factors as we take.
I'd ask you, because of the pressure of time on me, to look at our written case at paragraphs 333 to 338, where we do deal with this in quite some detail, and the case law that's referable to it. My lord, the short point we make about it, going back to the point about, I think it was my Lord Richard's point about what's different about success fees and legal costs, and I said prospective versus retrospective. In Section 5 applications, it's very normal for the court to give relief to enable the funding of legal costs. To enable the funding of legal costs.
Yes.
And that's often the reason why people make the applications. There's got to be liquidity of the estate, of course, and often there won't be. And indeed, it may be resisted, especially if the claim is seen as slightly lacking in merit, but there might be an argument about whether there was 2 years of cohabitation and so on. So these Section 5 applications are not entirely straightforward. The claim's got to be issued before you can make one, so you've got to have got to that stage. They take up considerable court time, so we certainly wouldn't encourage any outcome which throws the burden on judges to do lots of Section 5 applications. And they're not, the criteria are not quite the same as the exercise at trial, because the judge probably won't have all the information at that point. Necessarily, they're very interim, early stage applications. Forgive me for leaving that point very quickly because of the pressure of time. I think, in fact, that hopefully in the course of answering your Lordship's questions, I've probably, rather inelegantly, because I've taken it slightly out of my order, dealt with the third key issue, which is what is a costs order. Can I make one point on that as well? That costs orders, of course, not defined anywhere. Costs are in the CPR, and in the earlier version of the CPR, this is all dealt with at paragraph 4.3 of our case. They were included as costs, then they were taken out. Now, your Lordships might ask yourselves, if they were taken out of the definition of costs in the CPR, then what purpose can the CPR serve in interpreting what a costs order is in section 58A6? So that must refer to something slightly different, we would say, than the inter partes liability, the solicitor-client liability under the contract. That costs within the CPR not expressly, by omission, does not apply to success fees. We would say, if you translate that to section 50A6, a costs order, which we say common sense has got to refer to an order made under the CPR, does not include a success fee. Now, where you are left, my lords, is that we're just outside the Jackson costs reforms completely in this case. That is where we are. We are in a realm where you've simply got, because of the breadth of the Act, a claimant who's got a debt, can't recover it by any other means. It therefore, because of the breadth of the Act, which should not be fettered, it comes within that. It won't come within it in every case. Judges have to tailor-make the relief to the facts of each case. They've got to scrutinise it. They've got to decide. But as a matter of principle, which is what this appeal is about, it was open to the trial judge to make the decision he made, and we commend it to your lordships.
Can I just ask before you sit down, paragraph 58 of Mr Justice Cohen's decision, page 143, he talks about revisiting
Yes,
the
he
elements
does.
of the award. What's your understanding as to how that legally is possible?
Well, it may be that Mr Wagstaff is actually better placed than me to answer that, because
Certainly.
as I understand it, that's much more common in the family division. So with your leave, I will...
Thank you very much.
Okay.
I mean, it's all right in ordinary civil proceedings, as I understand it, provided the order has not been drawn.
Which it often won't have been before you've dealt with costs, because
Yes.
you'll include them all
Yes.
in the order.
Yes.
Yeah.
But if for some reason the debate about costs is delayed and the substantive order is made, then as regards that order, the judge is functus and can't revisit it.
Yeah, my lords, just building on something I said earlier about section 2.4, the court could always build in to an order a contingency so that the order itself is final, as in my submission it would if there were...
But a certain sum will only be payable for the depending on whether there's success in the action.
Yeah, and I'm happy to accept that such an order might need to be made on the facts of any particular case.
Right, thank you very much.
Well, if that's a convenient point at which to adjourn.
My lords, thank you. I think it is. If I have another 2 minutes when we come back, if I think I'm sorry, I've slightly taken out of order
Yes.
of my notes, I will speak to Mr Wagstaff over the break.
Well, we'll sit again. We'll sit again at 20 past.
Thank you.
Mr Wagstaff will have until 22, and then we'll hear the reply.
My Lord, on my calculation, it would be 10-2.
I agree.
That's correct.
We
I
agreed
have
that...
another 20 minutes, which is
Yes,
10
well,
to
yes,
till
you're
10
quite right.
past.
We're going to sit until 10 past 4, so you'll have until 10 to. Yes.
Thank you very much.
I mean, it's on the timetable.
Well, it doesn't provide on the timetable, so if both sides are happy with it...
Yes,
presumably
indeed. Yep.
Well, the timetable before me says the reply will be from 3:40 until 4:10.
It doesn't say when the break will be
It
taken.
doesn't say when the break will be taken, but I think the assumption is that the break will be taken during the respondents' submissions, because they occupy the bulk of the afternoon.
My Lord, I'm not sure the timetable...
Yes. So what I said originally was correct. Yes. So we'll sit.
It's a matter.
We'll sit again at 20 past, and you'll have 20 minutes. Cool.
Lords,
Mr. McDermott.
Mr Wagstaff has kindly granted me a further 60 seconds or so.
Microphone is not.
Oh, I'm sorry. Is that better?
Yep.
Mr Wagstaff has granted me 60 seconds to make a final point
Yes.
before I do sit down. And it's a very discreet one about the operation of Part 36, just in response to one of the appellant's written submissions. It's a point about disabling the ability to use Part 36 effectively because of the lack of information about a Part 36 offer. We say that that just shouldn't be a concern, because within Part 36 itself, one of the grounds upon which the court might decide that it's unjust to apply one or all of the consequences in Rule 3617. My Lords, I'm using numbers, but you'll recollect what I'm talking about, what flows from a claimant beating an offer. The express reasons for disapplying the provisions is the information that's given at the time of the offer. Not just the information that's given, it's the reasons for refusing it. And can I simply give you page references, please? If your Lordships look in the supplemental bundle at pages 24 to 25, and the notes upon that, the editorial notes at page 30, in fact, within the editorial notes, there's a reference to Lillyman on this point, because what Mr. Justice Briggs did in that case was to disapply the effect of Part 36, partly because of the conduct of the claimant. So we say that the ability to disapply Part 36 is a complete answer to the appellant's point about information.
Thank you.
Thank you very much.
Grateful. Thank you very much. Mr. Wagstaff.
I'm grateful for my learned friends for indicating that as far as they're concerned, I have until 10 to 4. I am entirely in your Lordship's hands. If your Lordship wants me to shut up and sit down at 22...
I wouldn't dream of suggesting that. Mr. Wagstaff, as long as the respondents are content, they were originally allocated 30 minutes, but if they're content with 20 minutes, then that will be a happy solution.
Grateful, my Lord. We have set out our points that I was going to deal with in relation to the family law analogy at some length in our written case, and I don't need to go back over that. Can I address 3 particular points that have arisen during the course of submissions so far? And I'll deal with my Lord Richard's point about the judge being functus, if I may at the beginning, just because it's fresh in everybody's minds. My Lords, there are 4 practical solutions to that problem. The first, as my learned friend has said, is to deal with matters on a contingent basis. If a success fee becomes payable, then the lump sum will be X, but not otherwise. The second is an appeal, which nobody would want, but if a judge has made provision for £20,000 in relation to a success fee that doesn't become payable, there is only going to be one answer to or one outcome to the appeal. And so, my Lord, that is a second possible solution.
With all the costs and delay that would occasion.
My Lord, that is probably why most respondents to the appeal would be very well advised to consent to the appeal.
That would raise further problems about whether the judge was wrong in deciding something correctly on what he knew, but incorrectly in the light of what he didn't know.
Well, my Lord, I suppose the respondent to the appeal has got a choice to make. One, they don't contest the appeal, in which case they are effectively accepting that the judge has gone too far. Or 2, if they want to, they can try and defend the judge's judgments. And if they lose, they pay a consequence in relation to costs. But that's a matter for them. The third option, my Lord, is the sort of procedural avenue. There are actually 2 different avenues in relation to this. It goes back to the case that my Lords dealt with about a year ago in Unger and Hassan. Your Lordships might recall reference there to the Barder jurisdiction, where one appeals in a relatively short time after an award on the basis that something unforeseen has happened which has upset the entire factual basis of the judge's award. There are, generally speaking, 2 procedural routes to that. One is as was considered in Barder, an actual appeal. The other is a set-aside application. And again, if there is a clear decision by the judge to take into account a success fee that in the end is not payable, again, the respondent to a set-aside application has got a choice as to whether or not to contest that or not. And as I say, precisely the same point arises in relation to the BARDA appeal jurisdiction. So, my Lord, I hope that that deals with my Lord's point about what can be done if the judge is functus. The second point goes back to this is a short point, and it goes back to an observation my Lord Stevens made this morning, which is, can everyday living expenses include the costs of litigating? My Lords, can I go in that context? My learned friend's reply was that Parliament didn't intend that. Can I go to the case of A&A, which your Lordships will find in the supplementary bundle. Pardon me, my Lords, I've just lost my note in relation to where it is to be found. It's in the supplementary bundle at page 450. A&A was an application for maintenance pending suit, so effectively interim maintenance during the course of financial remedy proceedings within a divorce. And the applicant sought, as part of a maintenance award, an allowance to cover her legal fees during the currency of the litigation. My Lord, I think I can go straight to the head note and only to the head note. This is a decision of Mr. Justice Holman, and this predates the specific jurisdiction that now exists to make specific provision for funding on an interim basis. So that's why A&A existed. But 3 lines down in the head note under the held section, Section 22 of the Matrimonial Causes Act 1973, which required periodical payments of maintenance pending suit to be reasonable and for the maintenance of the payee, was expressed widely enough to empower a court ordering maintenance pending suit to include an element towards the payee's costs of the suit. Maintenance was not statutorily defined, but per Mr. Justice Brown Wilkinson in Reed Dennis, which of course was a claim under the 1975 Act, the term connoted payments which would enable the payee to discharge the costs of daily living, being recurring expenses of living of an income nature. Maintenance payments were not restricted to matters of daily living in its most literal and restrictive sense, and legal fees incurred in the course of litigation were recurring expenses of an income nature. After provision of a roof over her head and food in her mouth, the wife's most pressing need was the resolution of her divorce claim. She would be unable to make any progress with the dominating issue in her life if she could not pay her lawyers. Conceptually, my Lord, at least query whether on the facts of any given case, but conceptually we say plainly a need to fund litigation either as one goes along at the interim stage or to cover the cost of litigation which one has incurred at the trial stage must be capable conceptually of being a maintenance award.
Mr. Wagstaff, I can understand that point and I can understand the reasoning in the context of a financial remedy case like this. But for my part, what's troubling me is the analogy which is drawn with financial remedy cases and whether it's an appropriate analogy at all.
But, my Lord, this case illustrates precisely why it is, because the judge here is plainly dipping into the jurisprudence of the 1975 Act, which is cast in, as we said in our written case, in very, very similar terms to the Matrimonial Causes Act, and has looked at the cases on what is maintenance and has reached a decision that this falls within it. In my submission, my Lords, maintenance in the context of the 1973 Act means the same thing, conceptually, as it does under the 1975 Act.
Well, I wonder if that's right, given the fundamental difference in the nature of the different jurisdictions, in particular so far as costs is concerned. Because, as I understand it, in the financial remedy cases, there's generally no cost shifting, save in situations where there's unreasonable conduct.
Well, my Lord, it's not quite that straightforward. The jurisdiction to award the cost shifting, if I can put it that way, can take place at 3 different stages. It can take place at the interim stage where conceptually that is based upon a funding requirement. It can take place at the trial stage, where conceptually that's based on an award to meet an outstanding need or obligation, or it can take place conventionally following judgment in the context of a normal costs application. It is true that in relation to Matrimonial Causes Act cases, that the general order is that there will be no order as to costs, save where there has been litigation misconduct. And two good examples are, one, breaches of the duty of full and frank disclosure, which are sadly relatively commonplace within the divorce jurisdiction. And the second is that where there has been a failure to negotiate reasonably. Yes. It must be said, my lord, that there is more of a move within the family jurisdiction towards making costs orders in more cases than has previously been the case, but that's perhaps a by the by.
Can I just ask, sorry, has that always been the position in family proceedings, or was it once more like civil litigation and then moved how you tell us, and then now it's moving back again a bit, or was it traditionally always the case that you expected in the divorce and financial remedy proceedings that the starting point was each party pay their own?
The secular courts were given the power to dissolve marriages in 1857, and at the same time they were given the first power to award financial provision, which was alimony, as it was then described. From that point through to 2005, costs followed the event. Mm-hmm. At that point, for almost exactly the same reasons as were explained by Mr. Justice Briggs in Lillyman, the Rules Committee decided that in financial remedy cases on divorce, the rule should be that there should be no order as to costs generally, save in cases where there was some relevant litigation misconduct or so, and so on and so forth.
Right. So you could make the point, for example, that Mr. Justice Holman in this case was working against the backdrop of a similar regime, was he, on costs to the general civil regime? My
lord, yes, and there's a further point which flows from that. There are three different jurisdictions where the court is given the power to make financial provisional orders arising from some familial or quasi-familial relationship. Obviously, the 75 Act is one. Obviously, the 73 Act is another. One that I'll come back to in the context of my next point is Schedule 1 of the Children Act of 1989. That is a freestanding power to award financial provision for the maintenance of children. Almost inevitably, the children are also minors, but in special circumstances, the court can make orders in relation to those who have achieved 18 and the rest.
Which section is there?
That's Schedule 1,
Schedule 1.
To Children Act 1989.
Thank you.
And I'm going to come back to that, my lord, in the context of my next submission. Schedule 1 claims, my lord, are not subject to the general no order as to costs provision. In Schedule 1 claims, costs follow the event. So when one is looking, can I just briefly give your lordship a reference to that? It's in the supplemental bundle at page 323. I'm not going to take your lordship through it, but if I go down to subparagraph 5 of Rule 28.3, your lordship will see that the general rule in financial remedy proceedings is no order as to costs, if I paraphrase. Financial remedy proceedings is defined in the preceding paragraph, and it doesn't include claims under Schedule 1 of the Children Act. If your lordships look further in the notes to that section, in particular at paragraph 3.1123 at page 324 and 3.1124 at 325, your lordships will see how we get to the point in those cases that costs follow the event. And if time permitted, I would take your lordships through, but time does not. The third point is referable to an observation that my Lord Stevens made this morning, which was to say that CFAs are contrary to public policy in family proceedings, and therefore they can't be the subject of, for instance, a success fee. That is not to say that a success fee can never be relevant in the context of either an application under Schedule 1 of the Children Act or, indeed, in the context of a Matrimonial Causes Act. Can I deal with Schedule 1 first? And it arises in this context. Would your lordships imagine a case where a couple lived with each other for 15, 20 years, they never married, they have 2 or 3 children, and then they separate? The litigation that follows, unless they can arrange their own affairs to their own satisfaction, is likely to include a claim under Schedule 1 of the Children Act, which deals with provision for the children. And in that context, the mother's claim, assuming it's the mother who is the claimant, is in essentially a representative capacity. In her own right, she has no rights to any discretionary financial provision as an unmarried mother, as an unmarried cohabitant. What she can do, of course, is look to her remedies under the general law. So, for instance, she might assert an interest under a constructive trust or the doctrine of proprietary estoppel in the family home. But what the court can't do is a discretionary adjustment of what the interests are. It can simply find what they are. For obvious reasons, my lord, and those claims tend to be litigated under the Trusts of Land and Appointment of Trustees Act of 1996. Those claims, because they arise largely out of the same facts and now between the same parties, in practice they get heard side by side. So can I imagine a judge sitting on a cold Thursday in Blackpool County Court in his room? He's just heard 3 days of evidence and argument about one of these combined Talata and Schedule 1 applications. The wind is whistling in off the Irish Sea, the rain is driving horizontally against his rein, and the judge is deciding that next year he's not going to sit during the summer vacation.
Blackpool's much nicer than that.
Of course, my lord.
The court building isn't.
The judge, thinking about his judgment, has got an asset schedule in front of him, and it includes a contingent liability for £30,000, which is a success fee payable under the Talata claim, because although the Schedule 1 claim...
Sorry, what's Talata for the uninitiated?
Trust of Land and Appointment of Trustees Act. That's effectively the vehicle for deciding if you've got an interest under a constructive resulting trust, etc., etc. The Talata claim can be litigated pursuant to a CFA. So you have 2 twin sets of litigation, one which can't be the subject of a CFA and another which can. So on the asset schedule, you've got a contingent liability for £30,000. The judge, of course, by this stage of the exercise, has been listening to the mother's evidence, and he was quite impressed with it, and he, subject to thinking about it further, thinks that she's going to succeed on her claim that there is a constructive trust arising in relation to the family home. That, because the CFA has been disclosed, is going to trigger payment of the success fee. What does he do about that, my lords? Can I go, in that context, to the Schedule 1, the terms of Schedule 1 itself? Your lordships will see this at page 376 of the core bundle. If I had time, my lords, I would conduct a side-by-side review of the 3 jurisdictions, Schedule 1, the 1975 Act and the 1973 Act, because the statutory landscape is very, very similar in all 3 cases. Each one gives the court wide powers to make a raft of orders that are tailor-made to the correct solution in that particular case. Each one has a range of factors to take into account, and that appears at paragraph 4 of Schedule 1, which your lordships will see on page 376. This is very, very similar to Section 3 of the 1975 Act and Section 25 of the 1973 Act. And in particular, the court is required under Section 4.1, paragraph 4.1, to have regard to all the circumstances of the case. And in particular, my lords, Subsection B requires the court to have regard to the financial needs, obligations and responsibilities which each person mentioned in subparagraph 4, that for current purposes, my lords, is the parents, has or is likely to have in the foreseeable future. My lord, a few points just about that exercise. It follows the same logic as claims under the 75 and 73 Acts do, which is that the first task is for the court to conduct the factual assessment of whatever the financial landscape is, in terms of an assessment of resources, in terms of an assessment of obligations, liabilities, etc., etc. Only when that exercise has been conducted can the court proceed to form a value judgment about how it should exercise the powers conferred by each of those three acts. That first stage, the computation stage, is purely factual, and it is conducted as at the date of trial, as with 75 Act cases pursuant to Section 3.5, as with Matrimonial Causes Act cases pursuant to a number of Court of Appeal authorities. And finally, my lord, just looking at paragraph 4b, needs is not only a matter of fact, it is entirely fact-based, but it's also precisely the same assessment under each of the three jurisdictions. If you are a single mother with 3 children, your housing need is exactly the same whether the case before the court is under the 75 Act, the 73 Act, or, as here, Schedule 1. That is a finding of fact. And equally, if the terms of a contract have crystallised so that a success fee is payable or is likely in the foreseeable future to be payable, that is a finding of fact that the court is required to take into account for 2 reasons. 1, it's one of the circumstances of the case. 2, it fits squarely within paragraph 4.1b, I should say. So going back to our judge watching the rain drilling against his window, my lords, how does he deal with that success fee? On my learned friend's case, it appears to be the case that he would have to ignore it completely.
Well,
now,
is that actually right? I mean, because the example you've given is actually different from our case, because the case we're talking about is the case where the costs in question are the costs in the very proceedings. Whereas I think what you're postulating, although I agree that proceedings are held at the same time and so on and so forth, you've got 2 sets of proceedings, separate sets of proceedings.
Unless those proceedings have been consolidated, of course.
Well, I don't know about that, but
2 separate claims.
2 separate claims. So the issue you're raising is not the same issue as that which arises in this case.
No, my lord, but the statutory language is. And
only apply the language to the facts, and there's a fundamental difference in the facts. That's. I just want to make that point.
Understood, my lord, but nonetheless, the language of the Act says, have regard to all the circumstances of the case, and the fact that, assuming this be the case, a contingent liability has crystallised is a fact of the case. My lord, whether or not the court goes on to do anything about it as part of the value
judgment. So has this ever arisen? I mean, is there any reported authority on the point you're raising?
My lord, there are a number of reported authorities which are Schedule 1 and Talata claims combined. I can't think of any that has dealt with this particular point. Okay. But, my lord, I only need one case where a Talata case has been litigated via a CFA containing a success fee for the jurisdictional point that this raises to be engaged.
No, I don't think so. But anyway,
your point's one of principle anyway. It doesn't depend on whether it has actually arisen in a case up to now. You're posing it as a problem that you say the other side's argument can't address.
My lord, and it's the point of principle, I suppose, also is a question of statutory interpretation, because here, as with the 73 and 75 Acts, we have the widest possible statutory language requiring the court to take into account the widest possible range of factors, liability under a success fee being simply one of any number that might be relevant on the facts of any given case. What my learned friend must say, although she doesn't as yet put the point like this, is that Section 58A(6) has the effect of limiting that wide range of factors that Parliament has already said must be taken into account and given such weight as the court thinks fit. Now, and that, my lord, applies across the 3 jurisdictions. I've been talking about a situation where the claims under Schedule 1 and Talata are dealt with together. There are many situations in which a civil claim that is related to an ongoing financial claim in divorce are litigated together. One of them is if assets are put beyond the reach of the courts, the applicant may seek relief under Section 423 of the Insolvency Act and to set aside dispositions. Another is that if, again I'll assume, it's the husband who has declared himself bankrupt within the course of proceedings, the wife might apply to set aside the bankruptcy if she says, for instance, that it's a complete charade and a sham. Those sorts of claims are litigated together with financial claims. I wouldn't say day in, day out, but it's not an uncommon occurrence. So, my lord, we have the same thing, that if those claims are litigated via a CFA, the Section 25 of the Matrimonial Causes Act says take into account all the circumstances. And yet here, if this is how my learned friend develops a case, she must be saying don't take into account that particular circumstance because of Section 58A.
But the other way of putting her case is to say there's no reason why you shouldn't, in your examples, take into account success fee or other costs of those claims. But the relevant principle is that that matters of costs within a particular litigation or claim cannot be dealt with, are the subject of that regime, and they're not to be dealt with as part of the substantive relief granted in the claim.
Well, my lord, that, in my submission, is precisely the same problem, because it is limiting either the range of factors that the court can take into account in the light of clear statutory language, or it's limiting what the court can do about it. In other words, you can take the fact of a liability under a CFA into account, but what you can't do is factor it into a lump sum. What you can't do is decide that the claim for a car should be allowed that otherwise might have fallen foul because you're effectively providing by the back door for that form of relief. It can't cover the situation that my learned friend pointed to, where you have relief under the 1975 Act, which is non-financial, such as a life interest in a property, such as the variation of a settlement or something of that nature. So there is a very, very clear, in my submission, limiting effect of Section 58A in the way that my learned friend puts her case, and there is no indication that Parliament intended that limitation, that limiting effect, in the words of Section 58A itself. I needn't tell this court that where an act is intended to have the effect of limiting earlier provisions, usually one would expect to see very clear wording to that effect. And here it simply doesn't exist.
Well, at the moment, it seems to me that success fees are no actually different in principle from any other form of costs order in the litigation, and that it's really all or none, and that either all the costs of the litigation can potentially be taken into account as part of the substantive relief, or there's a principle that litigation costs, because they're the subject of a separate regime, are not to be brought into account when you award substantive relief in proceedings.
My Lord,
for example, as they're not, as I put the example earlier, in any damages claim.
My Lord, yes, I take the point entirely that the outcome of this case is probably all or nothing. It still raises the question of whether or not a claim under any of the 3 jurisdictions that I've been looking at is limited in that way by saying you can't take into account that, and you can't do anything about that either. As I make the point, my Lord, that there is nothing within Section 58A that would suggest that, and that, in my submission, is a significant issue which I invite my Lords to take into account. My Lords, I am straining against my own extended time estimate. I would love to engage further with that particular point.
I haven't diverted you from making points you had to make. But
there it is, my Lord. These things happen. Unless I can assist further.
Thank you, Mr. Wagstaff. Stevens Hall.
My Lords, I'll endeavour to deal with points quickly and within the time limit. First of all, it's my understanding that, in fact, in this case, the claimant did have an interim payment. That was as a result of an order that wasn't resisted. It was only a very small one, £5,000, and I can provide a copy of the order if needs be. Maybe there's some dispute about that, but
doesn't really matter.
I've seen the order.
What's the impact of that?
I mentioned the case of De Gaga, but didn't give you the reference. That's the one that deals with the fact that where the CFA does not sit within the statutory scheme so as to be lawful, other routes can't be used. The references, the core bundle, starts at page 639. If I can just invite you to have a look at it, particularly paragraph 2 on page 642, that deals with that. So far as the non-monetary forms of relief under the Inheritance Act, my Lord Legate was exactly right as to our position. It is, if in order to make a particular order, it is justified or calculated by reference to the liability to pay a success fee, then it would be contrary to Section 58A6. My learned friend, Mr MacDonald, made reference to, so what's the position in terms of the meaning of costs order, since a lot of this is focused on settlement, around Tomlin orders and consent orders. To be clear, we would say a consent order is still a costs order. It deals with costs. So far as a Tomlin order is concerned, of course, it's the order. You have an order and then you have a contractual arrangement that sits behind it, which may or may not be known to the court and is not what the court is ordering. It's very often done as a Tomlin order because it contains things that the court couldn't order. So it is not a part of the order. If someone agreed to pay a success fee that's not otherwise payable and put it there, we would say quite possibly a court, if it could see that was happening, might well be reluctant to make the Tomlin order. And certainly there would be problems if one sought to then enforce it, where you would be having a very direct order of the court for the payment. So arguably you could put it in there and keep it confidential, and it would just have its contractual effect and not be something enforceable.
Would not be enforceable as a contract?
Yes.
I mean.
Indeed.
But it'd still be enforceable as a contract.
Yes, it would be enforceable as a contract.
Well, that's the way a Tomlin order works.
Yes,
it's actually a contract, but you don't have to issue new proceedings. You can enforce the contract in the existing proceedings. It's a procedural
you wouldn't
device.
be able to do, because as soon as you invited the court to make an order enforcing the contractual obligation to pay, you'd be inviting the court to make an order that was contrary to Section 58.
A different and not altogether straightforward issue that doesn't arise in this case, is my reaction.
It gets us into lots of detail about Tomlin orders. My learned friend gave a lot of anecdotal comment, if I can put it that way, about the impact of CFAs and recovery of success fees. As in another context, your lordships have mentioned, the Jackson inquiries looked at a lot of this. There's actually a lot of material about not just globally Chancery litigation, but some relating very specifically to family provision cases, i.e. the 75 Act. If I could invite you to have a look at, in the core bundle, I'll double check if it's the core bundle or the No, I think it's the Supplemental Authorities bundle. Page 1456 at paragraph 512.
What is this that we're looking at?
So this is in the preliminary Jackson report, and we can see at 512, Chancery litigation, just towards the bottom of the page, generally does not present particular difficulties with regard to proactive and sensible use of offers under Part 36. He then talks about some Chancery cases where that's problematic, and over the page, on the other hand, family provision claims do lend themselves to the use of Part 36. And then if we go on to page 458, at paragraph 520, in private client cases, e.g. trusts, will disputes and family provision claims, the potential effect of hostile orders as to costs is often, so experienced counsel in this field advise, the catalyst for early settlement, with or without formal mediation. This is another example of sensitivity to costs and experienced advisors being aware of this and steering their clients accordingly away from confrontation. And of course, the effect of a CFA with recovery through the award of the success fee is that the claimant has no cost risk, has no cost pressure, or very much less cost pressure in order to settle the matter. If they do not win, they have no liability or less liability, and that is one of the key reasons when we look at the government response for the reforms that were being made when the recovery of the success fee was removed, what I've referred to as the failed experiment. Before I take you back to that, Justin Jackson, if we can go to page 1461. So he, in the preliminary report, made his proposals and positions, which did not include a carve-out or any mitigations or adjustments of the type that were being contemplated for personal injury claims, and indicates looking forward to hearing comments from Chancery practitioners, etc.
So what was the page number again? Sorry?
Sorry?
What was the page number again? I'm terribly sorry.
1461, and it's paragraph 612.
Right.
An invitation to engage, and then when we get to the final report, the recommendations did not include any scheme of adjustment of the 10% type for Chancery cases, unless they happen to be in relation to damages. I said I would take you quickly to the, bear with me, government's response. It's that looking forward document, which we have on page 1469. Under the government intends to abolish the general recovery, we have the second sentence beyond that. Crucially, this would give individual CFA claimants a financial interest in controlling the costs incurred on their behalf. So certainly the reforms were proceeding on the basis that removing the ability to recover from the other side, the CFAs, the success fee was constructive in terms of encouraging settlement and controlling costs. To then turn to my learned friends Simmons and Castle points, I think your lordships, in general terms, have the points. If I can urge you to look at, and it's on page 1554, paragraph 7, 8, 9, 12, 13 and 14. As your lordships have variously highlighted already, this engaged at a very high level the judiciary agreeing to change guidelines that it was already established they had a duty to review and update. They only related to general damages, so in claims that very much involve people's loss of earnings, people's care needs, the sort of things that may be the relief we also feature in 1975 Act claims, that would not benefit from a 10% uplift. It is just the general damages. But really importantly, we can see at the top of page 1555 that this proposal in relation to the general damages was a recommendation by Lord Judge with the unanimous support of the Judicial Executive Board, previously announced, so prior to this, they had announced the judiciary's support of the package as the government had followed a consultation process, and the 2012 Act has been introduced by the Executive and enacted by the Legislature on the basis the reforms are a coherent package, and in particular that the judiciary would give effect to the 10%. It is an entirely different situation, both the change that is made, how it, we would say, is generic across the system adjustment, along with various other adjustments in relation to the Jackson reforms. It's one of several, and more importantly, the legislation that contains the provision we're dealing with was enacted on the basis of this proposal being put into effect by the judiciary. And the judiciary have power over common law damages subject to interference from Parliament. Here, there was an arrangement where Parliament took a step, the judiciary having collectively in the way set out in detail, taken a move. My learned friends are inviting you to say that it is acceptable for a first instance judge and then the Court of Appeal in an individual case, not part of a package, not part of what was contemplated and the package that was the basis on which the legislation was entered into, but to make an adjustment that is not in this form. And when we look at the package of recommendations, there are a whole range. It's not just the 10% and non-recovery of the success fees. It's also non-recovery of ATEs. It's limiting for those who are going to benefit most from the 10%, personal injury, clinical negligence claims, limiting their CFA uplifts to 25%, and various other provisions. Some that take place across the board, some that are more focused on particular areas. And everybody is clear. Jackson's report, the government's response, and what is said here, that it's a package. And that package did not include an adjustment or a freedom to the court to make changes in other cases to the ability to recover the service charge. Then if I can turn very quickly to the family analogy, we say it's not an appropriate analogy. My learned friends have talked about Matrimonial Causes Act. That is simply a piece of legislation that deals with one relationship, those involved in marriage. The Children Act, that deals with one relationship, parents and children. Both of those relationships, when people are alive, carry with them obligations. The Matrimonial Causes Act is engaged in redistributing, on the breakdown of the marriage, the matrimonial assets and where there is insufficient to meet needs, some potentially non-matrimonial property.
Obviously, it's a bit different, but it's a fair point, isn't it, that the wording is extremely similar of the different provisions. I
make the point again that, and it comes from the fact that those two pieces of legislation, Matrimonial Causes Act and the Children Act, deal with one connection between people, and they do move from a list of things that you have regard to the court having a discretion as to what to do about that. And that's unsurprising in the context of spouses and parents and children. The Inheritance
You've got those
Act,
relationships in the Inheritance Act too.
but the Inheritance Act is an interference with the testamentary freedom, which is a principle that English law has held dear. As said very clearly in Eilert, in the head note, it's on 731 in the core bundle, the statutory qualification to testamentary freedom made by the inheritance provision, enabling the court to modify testamentary provisions, is limited in the case of a child as a matter of deliberate legislative choice. And those limits are reasonable financial provision and in non-spousal maintenance. And my learned friend has sought to refer you to the position of maintenance between spouses. But again, it's a very different situation. In the Inheritance Act, you have to have the failure to make reasonable provision for maintenance. When you were talking about awarding maintenance between spouses, you are talking about the fair distribution of what is seen generally as the matrimonial assets that they both have claims and rights over.
Do you want to say anything in response to A against A?
So far as that is concerned, appreciate that's a view taken, and obviously maintenance is the same word used. This is, we would submit, very much a court trying to do what it could to protect the spousal relationship on an interim basis during the breakdown of marriage, in a situation where the only test is what are the means and needs, what's available, what should the court do, not the extra hoops that are involved and the pull that exists of testamentary freedom. You're talking about there is not an equivalence between the way, although the factors you have regard to, start again, all three pieces of legislation have a similar, not identical, but a similar list of factors. They have a similar list of forms of relief that can be given. In the family remedies cases, you go straight from the factors to the relief. As soon as you have the factors, then you have a discretion so far as the relief. The Inheritance Act asks more of you as a judge before you can get through that. And Eilert said you don't have to do it as two separate stages, but prior to that it had been seen as the threshold and then the quantification. So it's different in that way. You have, when you're thinking about Inheritance Act, think about the fact you can be dealing with people who are unrelated, but for 2 years there's been some assistance given. That might be assistance that is a million miles away from anything that would go on in a family. So it's a very different piece of legislation. It is very deliberately and consciously put in the civil litigation bracket. It is a situation where CFAs are allowed. They are not allowed the Matrimonial Causes Act or Children Act litigation. A decision has been made as a matter of public policy. It's not appropriate there. That signals a very different view about the legislation and what it's doing, because they absolutely are permitted for Inheritance Act claims. You're interfering with testamentary freedom of a person who is no longer
Not necessarily, because it may be intestate.
It may be.
And
you also... Sorry.
Section 5 application can cover anticipated costs on the basis of financial needs.
So...
And therefore...
There is a remedy to allow someone to bring the claim.
But the point that I'm seeking to make is that when you look at Section 5, potential debts, potential liabilities in relation to litigation costs are recoverable.
Yes. Or it's not that they're recoverable. Funds in order to enable you to fund the litigation is
so it's not
permitted. Where there's, and it's a very different test. Section 5, far more like the Matrimonial Causes Act, goes from need to discretion. It says it's immediate financial need.
Yeah. But it's
it doesn't
the same
do the
language of the factors in Section 3 apply when you're considering an application under Section 5.
Sorry, my lord.
The factors in Section 3 also apply under Section 5. And
yes.
That factor is financial need and obligations.
Yes, and we have accepted that your costs can be a financial need. What we say they are not, these costs, or any costs, properly so-called reasonable financial provision, as defined by the Act, and certainly not in maintenance-based cases, reasonable financial provision or maintenance. And so in this context, we would say Common should not be applied. Just checking, I know I've taken my time, I do apologise. I need to mention that I think we need to make an application jointly under Rule 47 for any submissions on costs to follow on, and I think we'd ask something like 14 days to give us an opportunity to
Yes, well, that's
digest
that would be
your
the
lordship's
usual course. And in this case, I can see that it's important that that course should be followed.
So if I can simply commend to you our written case, which obviously deals with some of the other details, particularly on the procedural points.
Thank you. Well, Ms Stevens-Hoare, Mr MacDonald, Mr Wagstaff, we're very grateful to you all. We've got through a great deal of material today in the time available. We're very grateful to you for your oral submissions and also for your written submissions. Grateful to your juniors for their assistance and also to those sitting behind you who have prepared the case for the benefit of the court. We will take time to consider our decision. We're very grateful to you. The court is now adjourned. Thank you very much.
Thank you, Your Lords.